So here's something that I think will surprise you as much as it surprised me. In 2019, I began working with colleagues at NYU's Climate Law Accelerator to build a comprehensive database of rights-based climate litigation. At the time, we identified 140 cases worldwide. Only 5 years later, by the end of 2024, that number had more than tripled, reaching 467 lawsuits filed across 6 continents. So the question is, what do these cases tell us about how law evolves to meet planetary emergencies? This is a fascinating question because it speaks about the evolution of the law. And then what new legal principles are emerging from this global experiment? 93% of all cases were filed since 2015. This is an explosion, not gradual growth. 90% focus on emission reduction, but then importantly, adaptation and loss and damage, or climate compensations, remain blind spots. 75% target governments. The corporate cases are rising pretty fast. Youth plaintiffs appear in cases worldwide, from the United States to Germany to Brazil. What struck me the most was the geographic spread. The United States leads with 94 cases, but Brazil follows with 53, then Germany with 33. But numbers really only tell part of the story. These cases are also creating new legal doctrines to address climate change's unique challenges. So let me walk you through this. Traditional law says you can't sue unless you're personally harmed differently from everyone else. But it turns out that climate change affects everyone. So courts developed new approaches. For instance, the European Court of Human Rights landmark Klimasenioren ruling exemplifies this evolution. The court recognized that elderly women facing heightened vulnerability to heat waves could represent a particularly affected group, even though climate change impacts society broadly. In Belgium's Klimaatzaak case, the court similarly ruled that widespread climate effects don't prevent individuals from claiming personal harm. And then there's another development that I really find fascinating. Governments often argue, why should we cut emissions when other countries won't? The Dutch Supreme Court in Urgenda debunked this defense. Every country must do its fair share. You can't shirk responsibility by pointing at others. German courts went even farther, using carbon budgets to calculate exactly what each country's fair share means. But perhaps most revolutionary is how courts are handling time. This is a crucial feature of this type of litigation. Climate change locks in future harms today. Germany's constitutional court ruled that current climate policies violate young people's future freedoms by forcing them to adopt radical measures against climate change when they become adults. The court beautifully called rights intertemporal guarantees of freedom. I remember presenting on these issues to the Inter-American Court of Human Rights in Barbados in 2024, where judges from across the Americas heard 3 days of testimony on climate change and human rights. For those of us in that courtroom, it felt like climate change itself was on trial. The judges weren't just hearing legal arguments. They were grappling with how to translate a planetary emergency into enforceable human rights obligations. Now, while most cases target governments, corporate litigation is where some of the boldest innovations are happening, actually. The landmark Milieu Defensief versus Shell case in the Netherlands ordered the oil company to cut emissions by 45% by 2030. The lower court in that case found that Shell owed a duty of care informed by human rights and climate science. Though an appeals court later limited this ruling, it established that corporations have climate obligations under human rights law. All of these open floodgates. Cases now target banks financing fossil fuels, supermarkets selling deforestation-linked beef, and cement companies contributing to sea level rise affecting Pacific Islands. One of the most important developments I've documented is how climate science and law evolve together. Nowadays, courts routinely cite IPCC reports as legal authority. The temperature targets of the Paris Agreement become binding through human rights enforcement. Climate attribution science, proving specific weather events were worsened by emissions, is becoming standard legal evidence. At climate conferences, I see independent climate scientists sitting next to constitutional law professors, learning each other's languages. This interdisciplinary collaboration is producing unprecedented legal innovations. My book reveals some interesting patterns. International and regional cases are fewer, but have outsized influence on domestic jurisprudence. Europe leads in Urgenda-style replication cases, while Latin America shows the fastest growth in litigation overall. Global South courts often link climate change to existing socioeconomic rights. And unfortunately, climate adaptation and climate reparations cases remain pretty rare globally. But there's also remarkable cross-pollination. People learn from each other across the world. Colombian court decisions are quoted in Norwegian cases. German constitutional reasoning spreads to Pakistan. A successful South African case against offshore oil drilling inspires similar actions in Latin America. This is what I call open source litigation. Strategies shared globally, adapted locally. So here's what these 467 cases represent ultimately. More than legal actions, they're laboratories for legal innovation. Courts worldwide are developing new answers to fundamental questions. Now, questions like who can claim protection from planetary harms? What do states and corporations owe to future generations? How do we enforce global responsibilities through local law? But the big question is, do these legal innovations actually change anything?